Good morning. I am Judge Lambert. Welcome to another oral argument session of the 5th District Court of Appeal by Zoom. We are having one Zoom hearing or Zoom OA this morning in case 21-1305, Reese Engineering Inc. versus Engineering Design Technologies Corp. Joining me on the panel today are Judges Edwards and Harris. You can see them there. Guide. A little bit. All right. Okay, a couple things. You see up in the upper left-hand corner, at least on my corner, is the clock. Each side will have 20 minutes today for their oral arguments. We will reserve 5 minutes for the appellant for rebuttal, unless you, Mr. Waugh, tell us a different amount of time, and then I'll have the marshal set the clock accordingly. We are on YouTube now, so we are being watched in theory by people who are interested in watching this. So please, for the benefit of the court and your opposing counsel, if you have any kind of electronic devices, phones, etc., please turn them either into the off or mute aspect so it does not go off and distract anybody during the argument. That being said, Mr. Waugh, if you're ready to proceed, you can certainly go ahead.
Thank you, Your Honor. May it please the court. Good morning. I'm Christian Waugh from the Waugh Grant Law Firm. I have the privilege of representing Reese Engineering, the appellant in this case today. I am going to ask for a 3-minute rebuttal reservation instead of 5 minutes.
Okay.
My client primarily appeals 2 matters from the trial court in this case. First, the trial court erred by entering final judgment in favor of appellee EDT as to both the amended complaint and the counterclaim. There are many reasons why this was error, but one of them, which we note in the brief as a separate matter to be appealed, was the trial court's denial of the motion for directed verdict as to count 2 of the amended complaint. And the second primary matter to be appealed is the trial court's denial of Reese Engineering's motion to dismiss for fraud in the court. If the court ends up—
Well, let me ask you about the fraud right now. You don't mention the fraud motion until page 54 of your brief. Is that correct?
Correct, Your Honor.
And you don't even tell us on page 54 what fraud you're talking about. Instead, you refer us to record pages 267 to 691 and basically ask us to figure it out for ourselves. Do you understand that you likely have waived that argument by not briefing it in your initial argument, in your initial brief?
Your Honor, I don't believe we've waived it, but I think that
you certainly haven't told it. You have not told us in your initial brief anything about that claim other than you're unhappy that the court denied your motion. You don't tell us even what fraud it is, do you?
We did explain that it's related to the counterclaim, Your Honor, in that Ms. Lease explained at trial that she was the one who authored something, and there's a bounty of evidence showing that's not the case. But the court is correct that we didn't make it the main point of the appeal. We didn't spend a huge amount of time on it, and that's because the most important part is the trial court's decision on the final judgment.
All right.
So we're appealing both, but we are going to spend most of this argument on the final judgment. And the main thrust of this appeal is that the trial court awarded EDT final judgment for both counts of its amended complaint, namely the breach of contract claim as well as unjust enrichment. In order to understand why not just 1 or 2 reasons are reversible error here, I have to explain there's 4 sets of damages that were awarded. The first set of damages is that EDT claimed Reese Engineering didn't pay it for out-of-scope services. The second damages are retainage that my client withheld and that would be paid at the end of the project. The third set of damages is interest that accrued on those first and second damages. And the fourth damages are damages that both parties agree were inside the scope of the contract, but which EDT claims were simply not paid. And so beginning with the first damages, about $15,000, Your Honor, this was awarded—
Before you get to that, you said that EDT agreed that all the money was within the scope of the contract?
Only on the fourth set of damages, Your Honor. In other words, this was an amount that is awarded for
the HVAC.
I know, Your Honor, that's in the first set of damages.
Okay, all right.
Thank
Thanks
you,
for clearing that up. Thanks.
Thank you, Your Honor. So in the first set of damages, which was almost about $15,000, this was awarded by the trial court for count 2, unjust enrichment, not breach of contract. Even though EDT actually did ask for this in its complaint as part of the breach of contract, and even though EDT actually pled this count 2 in the alternative to count 1. This was error for a few reasons. One,
Why can't they do that? Why can't they plead in the alternative?
Oh, they absolutely can plead in the alternative, Your Honor. But the reason why it's error here is because count 2 only has any relevance if there's no express contract governing the substance between the parties. And that was undisputed, which is why we moved for directed verdict at the end of EDT's case in chief. So for example, that directed verdict should have been awarded because EDT put the contract into evidence. No objection, wasn't disputed. Once that happens, if the contract governs the relationship, then all the services provided by EDT under that contract are governed by that contract. And
but isn't their argument that the unjust enrichment claim is for damages not covered by the contract? And isn't that what the trial court found?
Your Honor, it is. What the court actually found is that those out-of-scope services should have been covered by unjust enrichment. But what we showed to the court is that during their presentation of evidence, first of all, there's certain elements to unjust enrichment. They didn't put any of those into the record on their case in chief.
I just want to be clear. You seem to be arguing, maybe if I'm wrong, what I'm hearing is because there's a contract, that's the end of the discussion. And that's not really right, though, is it?
It is for two reasons in this case, Your Honor. It isn't always.
That's the principle is appropriate that if we have a contract and then there's some services done or outside the scope of the written contract that the party who provided the services expects to get paid, they can bring a claim for unjust enrichment. And that's what, I mean, I know you disagree with, factually that's what applies here, but that's a correct principle of law, though.
It is a correct principle of law, and I don't deny that a party can plead almost anything in the alternative in a pleading, Your Honor. The reason why it doesn't carry here is twofold. One is that, first of all, I mean, as a factual matter, EDT, and this is in our brief, EDT never put into evidence that they weren't paid for those services. They did that later on in Reese Engineering's case, but without that evidence, you can't prevail for not being paid on those things, whether it's unjust enrichment or a breach of contract. But more importantly, for the purposes of a motion for directed verdict, Your Honor, EDT's theory is that this is not, the reason why breach of contract doesn't apply and unjust enrichment does is because allegedly Reese Engineering requested those services. Again, that was not put into the case in chief by EDT, and it was not pled as an affirmative defense. A reply to our affirmative defense. We had two affirmative defenses on these points, and for EDT to waltz in and prevail on something that should have been in a reply is reversible error.
Well, what was your affirmative defense in that regard?
We had two affirmative defenses, Your Honor. One is that where an express agreement exists and covers the matter, the subject material between the parties, no cause for unjust enrichment can exist. And so what we would suggest to the court is in that scenario, it's incumbent upon EDT to file a reply and explain as an avoidance why that principle, which the court and I just talked about, wouldn't be dispositive. And
they denied your affirmative defenses, didn't they?
They did deny it, but in order to avoid the affirmative defense, they have to provide some fact as to why, if we prove it, which we did, there's an express agreement, why that shouldn't carry the day. And in this case, what they should have pled was these were extras that were requested by Reese Engineering. And there's no evidence.
That's what the testimony from Mr. Hallman was, is that the HVAC was out of the scope and that Exhibit 18 was the invoice for that. And then one of your witnesses agreed that there was a dispute over whether HVAC was or was not in the scope, that she thought it was, that Hallman thought it was not, and ultimately that he agreed to do the work. There was never, despite what's said in your brief, there was never an agreement that I saw in the testimony where Hallman agreed that the work was within the scope. He agreed to do it. Is that correct?
That is correct, Your Honor, but those matters were all brought up in Reese Engineering's case. My point is that at the point when Reese Engineering moves for a motion for a directed verdict, the evidentiary record is limited to what EDT's case was. And in EDT's case, they never presented evidence that EDT was requested to do it as extras. And so without that, they can't prevail, and the directed verdict should have been awarded. I'd also point out that, I've already covered the affirmative defense point. We think that pleadings matter. And so then I move on to the second damages. The second damages that should have been not awarded to EDT is the retainage that was withheld. These funds, about 10% from most of the invoices that Reese Engineering and its higher ups on the construction project withheld, should not have been awarded to EDT. The contract is very clear on this point. Reese Engineering has no obligation whatsoever to pay EDT until it itself is paid by WPC. That obligation is, according to the terms of the contract, a condition precedent to its payment. There's other sentences in the contract where consultant EDT has to agree that they accept the risk of this. Now, the trial court in the final judgment accepted EDT's argument that Article 10E of the agreement, which survives termination, specifically requires these payments to be due, quote, upon termination. But that reading is false. Those words do not exist in that section. They do not occur anywhere in the contract. They also don't make a whole lot of sense. The undisputed evidence in the record is that Reese Engineering didn't get paid until 2 years after this lawsuit was filed. That should operate alone to prevent.
Your opponent makes the argument that Article 3 doesn't carry forward. It's not listed in 18 as one of the provisions that survives termination. How do you respond to that very directly?
I think there's two arguments, Your Honor. Directly speaking, it doesn't go back in time and rewrite the relationship between the parties. In other words, things that happened in the past, that section doesn't say, well, if it was withheld in the past, it immediately becomes payable. It doesn't rewrite the relationship between parties. What it does is it governs the relationship going forward. And that makes sense. So if EDT was going to keep doing work, then it wouldn't have stuff withheld. But the other argument is that I think, Your Honor, if it's interesting because EDT also pleads that it's entitled to interest, 18% interest under an attachment A in the contract, which doesn't survive. It doesn't survive termination. And yet they're claiming 18% interest. So I don't think it's a great argument. Additionally, Your Honor, we have affirmative defenses on point. And yet again, I would suggest to the court that if they want to claim that the affirmative defense that it was outside of Reese Engineering control doesn't apply, then they need to explain why. Why didn't, if we prove that WPC didn't pay it, they need to provide some kind of factual issue as to why we should be held responsible for it. They didn't. I've already covered interest. If the first and second damages can't be awarded, then interest can't be awarded. And the fourth damages, Your Honor, is, this gets more into the facts, but what we are suggesting to the court is the construction phase services, the amounts that were in the scope. EDT did not put competent substantial evidence to justify it. What they did is they essentially put evidence in for Mr. Hallman that he said, I did everything. I performed everything except for the record drawings. And that's not enough. We cited a case in our brief, Puya v. Superior Pools, it's a fourth DCA case that says percentages are insufficient. You have to explain either with invoices or quantum merit evidence, some kind of analysis, what the cost was and what was lost. It wasn't done. What we did do is we went exhaustively in our case and showed just what was done and what wasn't done and why EDT shouldn't be paid for it. Again, we have affirmative defenses that are on point. For example, one of our affirmative defenses is that EDT is billing for work that EMI performed. Reese Engineering had to hire another contractor. The trial court didn't engage in analysis at all, even though there's evidence in the record that they were paid $16,000 and that this should have been a set-off. The court just said, I'm not going to address these affirmative defenses in the final judgment. Another affirmative defense. Your
Well, I
Honor,
mean, the judge says in essence, you didn't prove your affirmative defenses, right?
I wish that's what the trial court had said. What the trial court actually wrote was they will not, I don't have the exact language, but is not going to engage in an analysis of the other affirmative defenses.
Says the court rejects all affirmative defenses presented by your client.
Right.
So, I mean, how do you not interpret that to say, okay, you have the burden of proof, you haven't met your burden of proof on the affirmative defenses, and therefore I, as the trial judge, reject it, and why aren't we bound by that factual finding based upon the assessment of credibility and et cetera that trial judges make?
Your Honor, if the court had wrote that in the final judgment, I would agree.
I'm reading it. I'm reading it right here. The court rejects all affirmative defenses presented by Reese.
But what the court said is, why shouldn't we interpret that as I've assessed the burden of proof, you didn't meet the burden of proof, you didn't prove it, I assessed.
So you don't like the verbiage when the judge says I rejected instead of you didn't meet your burden of proof? Is that what I'm hearing right now?
No, Your Honor, I simply suggest to the court that words matter. And if the court had engaged in that analysis.
Well, you are saying that exactly to me. You don't like the words that the judge used. Oh, the judge she rejected your affirmative defenses.
The court definitely rejected them, Your Honor. I think it's reversible error for several reasons. And one is that the trial court abandoned its duty to even weigh the evidence here. In the brief,
what do you base that statement on?
Yeah, why?
Well, in the initial brief, Your Honor, we provide a huge amount of citations.
Well, the test is whether there's competent, substantial evidence supporting the judge's ruling, not whether there's conflicting evidence that you could point to and say, well, yeah, there's that, but we have this. That's not the test. The test is, was there competent, substantial evidence? When the judge rejects your affirmative defenses, for whatever reason, it rejected them. And, the burden of proof, pleading, whatever, it rejected them. You started out this argument by saying it didn't consider them. That's totally inaccurate. It rejected them.
I would suggest to the court that given the amount of evidence in the record, that it may not have been weighed. Again, we cite the court Puya v. Superior Pools. Percentages are insufficient. Mr. Hallman's sentence that I just did everything is not sufficient. And then we also, of course, appeal the final judgment as to the counterclaim. Reese Engineering filed a counterclaim for breach of contract and tortious interference. The trial court found that Danielle Lease was not an agent of EDT, even though, again, EDT didn't have any affirmative defenses on this point. We think it was an abuse of discretion because even if it had been written by Danielle Lease, that still would have bound EDT based on all the facts and circumstances in this case. Danielle Lease.
But didn't the judge look particularly at that point and find that Danielle Lease acted on her own, that she used her personal email that nobody else had access to, and the judge specifically found that she was a credible witness? So again, there was competing evidence and competing arguments, but it's not a question of abuse of discretion. It's, was the judge's decision supported by competent, substantial evidence? How do you say it wasn't when Danielle Lease testified as to what she did and Hallman testified that he had nothing to do with it? How is that not competent, substantial evidence?
Well, Your Honor, I certainly think it is evidence. I do think it's an abuse of discretion given the weight of the evidence on the other side. I am going to reserve the rest of my time. Thank you, Your Honor.
Okay, very well. Okay, Mr. Levine, go ahead, sir.
Yes, sir. Good morning, Your Honors. Stuart Levine on behalf of the FLE. I will refer to it as EDT. The trial court's final judgment on count 1, breach of contract, and count 2, unjust enrichment, are supported by substantial competent evidence and should be affirmed. The defenses raised by the appellant were rejected. They were properly rejected because there was no evidence presented to support them, and they were basically legal affirmative defenses that didn't overcome the.
Well, I mean, I don't know that there was no evidence presented. It's just, as Judge Edwards was pointing out, over and over, that correctly, that the judge heard conflicting evidence and made a determination as to what evidence she thought was more credible and supportable, and made findings. I mean, Mr. Waugh certainly put on evidence regarding his affirmative defenses. The judge just rejected it, that didn't prove it. Right?
I stand corrected. I would agree with your honor, Judge Lambert, that is a more accurate description of how the court dealt with the affirmative defenses. All right. So I want to discuss the paid when paid clause, because this entire lawsuit was predicated on, we don't have to pay EDT because we haven't been paid by the general contractor. The facts of the case are stipulated to that this contract was terminated for convenience in accordance with paragraph 10B of the contract. That's Trial Exhibit 4 at record 2A-1634. Paragraph 10B allows for termination for convenience. I think Judge Edwards, you pointed out Article 18. Article 18, when you terminate for any reason, including for convenience, certain paragraphs survive, certain paragraphs don't survive. One of the paragraphs that do not survive is Article 3. Article 3 is in fact the paid when paid provision within the agreement. Now, the next question you'd ask yourself, well, how do you get paid if you're terminated and Article 3, the payment provision, goes away? That is simply answered in paragraph 10E of the consulting agreement. And 10E provides that the consultant shall recover, subject to Article 3B, shall recover from the design consultant as complete and full accord and satisfaction for terminated, canceled, or suspended services, the actual unpaid cost of all services, satisfactory completed by consultant up to the date of termination, cancellation, or suspension, subject to offsets or back charges imposed by the design builder, owner, or design consultant. Consultant waives any and all claims for anticipated profits, loss overhead, or any other claim or theory arising out of termination, cancellation, or suspension of the agreement. So there is a quid pro quo that's provided for should the contractor, this contractor, decide to terminate this agreement, and that is you get paid for the services you performed to date, subject to paragraph 3B. 3B says when you submit your invoices, you have to describe what you did. So the paid when paid clause did not apply, and there was no reason, and the court interpreted that language consistent with how I just read it to you, for Reese, the appellant, not to have paid EDT, the appellee, upon termination. The court found in an alternative manner in paragraphs 36 through 43 that there was no reason Reese should have not paid, the appellant should not have paid the appellee, because there was a application for payment that the contractor had submitted to Hillsborough County. That's Exhibit 114 to the trial. I can get you the record site in a second. That was submitted to the county that listed the exact amount of money owed to the appellee EDT that is contained in Exhibit 18. And the condition was, get us an indemnity from appellee because he's suing our bond, he's suing our surety. The contractor says, we are not going to pay someone who's suing our surety. And at the time the release was asked at the last date, that lawsuit against the surety by the appellee had been dismissed. So the court said, what was your reason then for not having given a release for a claim that had been dismissed against the contractor's surety, and make the payment for the amount of money that you've provided, that you've requested from WPC on behalf of Reese? So there was an alternative reason, even beyond and above the fact that the paid when paid clause does not apply when there's been a termination.
What is your argument in response to Mr. Waugh's position that, you know, you should have filed various replies to his affirmative defenses, and therefore by not having done that, these arguments basically shouldn't have been considered by the trial court at the time the motion for, I assume it was motion for judgment of dismissal, since there is no jury for a motion for directed verdict. But
right. He referred to it as a directed verdict. It's a motion for involuntary dismissal under the rule. Right. The response is the only issue raised in the trial court below as to involuntary dismissal was the affirmative defense that you can't plead unjust enrichment when you have a direct contract. That was the only argument made. There wasn't an argument made. He hasn't proven his prima facie case. He hasn't put on evidence of to overcome our affirmative defenses. All the arguments he's raised on appeal, not a single one of them, other than the argument that you can't plead unjust enrichment at the same time you plead contract, wasn't raised. So it's been waived for the purposes of this argument. If he would have come in and say, Judge, they never really put on this and never put on that, it's a bench trial. It was said, Judge, I guess I missed it. May I please reopen my case? Thank you for pointing out, your counsel, that something wasn't raised. But I wasn't given that opportunity.
So is that in essence your an argument that in response to that, the evidence in support of your out of scope damages was presented during, not during your case in chief, it was presented during the defense?
No, our out of scope was presented in our case in chief. The record supports the trial court's finding of fact that the HVAC and generator work was out of scope. That's trial exhibit 18 at 2A 1726, and the testimony of Mr. Hallman at 2A 807 through 809 describe what that work was and how that work was out of scope, and that was in my case in chief. That wasn't outside in any other person's case.
That work was requested by WPC, right?
Yes, and the work was requested by WPC. Rice directed this work. You can find that at record 2A 1995 through 1000. Ms. Gorich directed this work. She also has an email, trial exhibit 30, which is at 2A 1733. Her email directs this work.
Was Rice ever paid for the work?
I don't know, because Rice—
If they weren't paid, how could they be unjustly enriched?
Because the permit could not have been issued. Rice could not have performed its agreement with WPC and put itself in ability to even seek payment without this work having been performed.
Are these unjust enrichment damages, were they pled?
Yes.
Where? I've got a complaint and an amended complaint.
All right.
Where do you talk about out of scope work?
I'm going to my file right now, Your Honor.
I mean, you got the breach of contract, and then you count 2 as an alternative claim. It's not an additional claim for extra work. It's just another possible remedy to recover the same exact damages you asked for in the first count. Isn't that precisely what Mr. Waugh argued you're not allowed to do? Unless I'm missing something in the complaint. It doesn't look like you ever allege anything about out of scope work.
Well, we knew we had a change order that was out of scope.
Why wasn't it pled?
It was placed into evidence without objection of it having not been pled. The obligation to object—
The out of scope work was tried by consent?
The out of scope work was absolutely tried by consent because it was a part of our original claim, and it was tried by consent.
Where was it part of the original complaint? That's what I'm missing, Mr. Levine. I'm looking at your complaint. I'm looking at your amended complaint.
Okay.
I see nothing about out of scope work being asked for anywhere. I mean, you re-allege the same paragraphs from the first count. You ask for the same amount of damages. I don't know where this is anything different than what was asked for, and you call it an alternative count.
Understood, but the objection at trial was we're not allowed to plead, and the objection only came in after the evidence came in through Mr. Hallman that this was out of scope work. The objection should have been immediately raised. Objection, relevancy. There is no pleading supporting a claim for out of scope work in the unjust enrichment claim. They had an obligation if they believed that the change order 18, exhibit 18 was not specifically pled and included in an unjust enrichment count. They should have objected to the evidence coming in the first place. They didn't object to the evidence coming in the first place. They didn't move for an involuntary dismissal until the conclusion of our case and limited to the premise, the legal premise, not the factual premise, the legal premise that you can't plead in the alternative. So yes, they tried the unjust enrichment case by consent because they never objected. They didn't object in their motion for involuntary dismissal. They didn't object at the conclusion of the trial. So I would answer yes. With respect to, I have 9 minutes. Okay. So we put on evidence in our case in chief that it was out of scope. We presented the invoice that it hadn't been paid. Mr. Hallman testified he had not been paid. There's a certified application that from the contractor to the owner seeking these identical set of monies. The permit could not have been issued without this work being performed. Reese directed the work to be performed, and our answers to interrogatories, which are a part of this record at 1A 644 through 648, describe in great detail exactly what work.
So you're saying Reese was enriched because they were able to get a permit?
No, Reese was enriched because they were able to fulfill their contractual obligation to the owner. And
Okay, how do you calculate damages if that's the enrichment that you say you proved?
Because that's the amount, because that's the exact same amount of dollars they submitted to the owner in Exhibit 114 to the trial. Our number, $70,000, is on that application for payment. They interfered with their own ability to collect that money by not giving them a release for our services. Unjust enrichment doesn't necessarily have to equate to dollars. So it doesn't have to mean you weren't paid money. They received the value. They received the value of our services. Reese could not have completed its contract with the contractor without having received those services from us.
At the time it received that invoice, did Reese raise any objection to it?
No, in fact, the evidence was subsequent to that last invoice, there wasn't any written response from Reese. And I think the testimony from Mr. Hallman was not a single one of his invoices were ever objected to. I think Ms. Gorick testified to the same. And I think Mr. Burgess, the vice president, also testified. There was never a written, we don't agree with your invoice. We don't agree with your description. It's, you haven't been paid yet. This whole lawsuit has been about paid when paid. The
invoice here for the out of scope, getting back to that, says,
yes, sir,
as requested by WPC. It's the only invoice that says that, right?
It's the only invoice that's the only invoice that we put into evidence with regard to these services. Yes.
And
sir.
it says as requested by WPC, not by Rice or Reese.
Right, but the evidence at trial was that Reese requested it.
Well, it was an email from, well, I forgot her name. It just says, thank you for agreeing to do it.
Well, she
doesn't really,
testified.
I'm sorry.
Gorick does say in her testimony when asked, did you instruct him to do the work? And her answer is simply yes, isn't it?
Yes.
And the trial court in the final judgment found that Reese had requested it.
Yes, sir.
Go ahead.
All right. So, it wasn't really discussed in the oral argument, but the entitlement to set off was denied factually because the replacement engineer, all he did was changed work. There was nothing that this replacement engineer did but changed work. And Mr. Burgess, the vice president, at record 2A 1106 through 1122, walks through each of the changes that this engineer did that resulted in this project being extended and services in addition to and out of scope of what EDT had performed. The issue on the interest was not raised in the trial court below. The only interest argument raised in the trial court below was you can't have interest if the paid when paid clause is enforceable. Interest should not be accruing against us, Reese, if the paid when paid was enforceable. That interest argument was the only one that was raised. Any other interest argument they have on appeal has been waived. It was not addressed in the trial court below. With regard to the prima facie case of the breach of contract and the unjust enrichment, if you take a look at the record 2A 773 through 809, first of all, that wasn't raised in the trial court below. That argument's been waived, but just to address it, because again, when they moved for involuntary dismissal, if we read the record, the argument was a technical argument. It wasn't a factual predicate argument. And so any argument that there wasn't a prima facie case was waived. But more importantly, there is a prima facie case. If we look at the record 2A 773 through 809, every invoice is put into place. They're described in detail. And the record is clear that a prima facie case was prevented and the judgment was supported by substantial competent evidence, particularly in light of Exhibit 114, which was the application for payment.
Do you want to address, you're getting down to your last 3 minutes, so do you want to address the appeal regarding the counterclaim and the motion to dismiss for fraud?
I think that Judge Edwards,
You're adopting Judge Edwards' argument?
yes, I think Judge Edwards described what I would say, which is that that entire counterclaim delayed this trial by a year. It was absolutely frivolous. It was made up.
I don't think he said that, but I mean, go ahead.
I saying that it was absolutely frivolous. It was made up, make believe stuff. It cost a lot of money to deal with. In fact, it cost more money to deal with that issue than putting invoices into evidence for work performed. And the judge didn't buy it, and the judge called it speculative. It was a fantasy. It never happened. And the judge was correct in not granting the fraud on the court, which is an extremely high burden. And I can tell you as a litigator, when your client is accused of fraud on the court, it's disturbing. But this one wasn't that disturbing because it was so outrageously far afield, kind of like the comments made about Moby Dick and South Park in the briefs. It was just way out there, had nothing to do with reality. So that's all I'm going to say about that.
Okay. Anything else?
No, unless there's any other questions, I want to thank the panel very much for your time.
Any questions? No? All right. Very well. Thank you, Mr. Levine.
Thank you.
All right, Mr. Y, the clock says you have 2:37 in rebuttal. Go ahead,
Thank you.
sir.
Thank you, Your Honor. There are two issues I'd like to address that were raised. One is that this idea of trial by consent. No, this was never tried by consent. What 50
Where did you object to it then?
Your Honor, there was no objection and no objection needed to be made. Under 50 CA case law, an issue is only tried by consent when there's evidence introduced into evidence if the evidence is only related to the unpled issue. Here, we're talking about an invoice that was directly relevant for the breach of contract issue as well. Therefore, there was nothing that was tried by consent. The second matter,
Ms. Gierach, if I'm not sure if that's how you pronounce her name or not, Katie Gierach or whatever it is, she agreed that there was a dispute between her and Hallman over whether HVAC was in the scope or not. She thought it was, he thought it wasn't. He agreed, and she says that's all that means. He agreed to do the work. And then there's testimony, and again, that I referred to at 998 of your appendix 2. She was asked, did you instruct him to do the work? And she answered yes. And did he do the work? And the answer was yes. So if it's outside the scope as he claimed, which is what their claim was, and they sought money for that, how is that not trying unjust enrichment for damages for work done outside the scope?
it wasn't, Your Honor, at the time that the motion for directed verdict on that count was made. And so none of that evidence was in EDT's case in chief.
No, Hallman definitely testified it was out of scope work and they did it.
As directed by WPC, Your Honor, and
but that it was out of scope work and that they did it was definitely in there. The fact that Gierach told him, instructed him to do that, I agree, that comes up in your case, not in their case in chief. And I have a question for you as well. This South Park cartoon that you decided was important enough to reference in your brief, you expected us to watch that, and I did. And I'll tell you that the cartoon's in poor taste. I don't see really how it's persuasive. At this point, I wonder if you're feeling a bit like Kenny.
Thank you for the question, Your Honor. Not yet. I may when I see the court's opinion. I think it is persuasive. I take what the court is saying. It's certainly different, but it's really just made for the analogy. There's a missing gap in EDT's contractual interpretation, and it shows. Thank you, Your Honor.
Okay. All right. Thank you, counsel. We will stand adjourned and take the case under advisement. Have a
Thank
good
you.
day.
Thank you.
Thank you.